Welcome to the Supreme Court of the United Kingdom, where we are today embarking on the second day of the hearing of the appeal in the Heathrow Airport case. The case is concerned with the government's decision to favour the development of a third runway at Heathrow Airport, and that decision has been challenged by a number of environmental organisations, Friends of the Earth and Plan B Earth. Details of the case can be found on the court's website by clicking on Cases and then following the link to Current Cases. Briefly, the government's decision is being challenged on the basis that it failed to take adequate account of matters relating to climate change, in particular the Paris Agreement. We're currently hearing submissions on behalf of Friends of the Earth, presented by their counsel, David Wolfe, Queen's Counsel, and I'll invite Mr. Wolfe now to resume his submission. Mr. Wolfe.
Good morning, my lord, ladies. Can you hear me okay?
Yes, perfectly, thank you.
I'm grateful. I'll pick up, my lord and lady, where I left off yesterday. I had just taken you fleetingly to pages around 472 in the bundle, which is in the Divisional Court's judgment, where the Divisional Court dealt with and dismissed a ground of challenge that was live from Friends of the Earth at that stage, but wasn't persisted with. What we need for this purpose is paragraph 627 and 631 of the Divisional Court's judgment. In 627, they summarise the submissions that we were making, focused on paragraph 5.82 of the ANPS, and in particularly in legal terms, focused on the proposition that those paragraphs were insufficiently clear in stating government policy. So that was a section 5.8 argument, different to Mr. Crossland's and not persisted with following these exchanges. 6273 in particular is one I want to look at the moment, where the proposition was, or the question was, what target or targets are referred to in paragraph 5.82, and in particular whether it's a reference only to 2050 target, whether it relates to international non-statutory targets such as the aviation target and or the overarching goals of the Paris Agreement. And the answer to that comes on page 474 of your bundle, subparagraph 3, again in the middle of that page. The reference to carbon reduction targets, including carbon budgets, in paragraph 582 is to the targets, including those in carbon budgets set by the CCA 2008, cannot refer to international targets, etc. And then it's carried on and explained why that was the case. I'm not going to trouble you with the detail of that. That the simple point was that clarified, and the point's not been resurrected by any party, that the tests being set by the ANPS were focused entirely on CCA obligations, albeit picking up international aviation as well. You see that from one of the other answers. And therefore, just a reminder of the proposition we were dealing with yesterday afternoon, therefore the ANPS test in 582 doesn't embrace other considerations such as those arising from Paris or non-CO2 or post-2050, because those matters are not within the CCA test. And more importantly, not to go back to 5.82, 5.82 specifically cut down or focused the question to be answered at the DCO stage, identifying a very limited basis upon which climate change could be a basis for refusing DCO permission, the effect of which therefore was in practice to preclude, in all but theoretical terms, a refusal of DCO permission by reference to the wider considerations. And that's an important kicking off point in terms of the question of how the ANPS might have been different. The ANPS might have been different because that test might not have been there. There might not have been a stop-go test in the ANPS. Alternatively, the Secretary of State might have paused and said, is now the time to be making an ANPS when matters are so in flux in relation to climate change understanding, or he might have formulated a different ANPS test which specifically allowed for consideration of those wider factors. Well, lady, I'm going to go on just in a moment to deal with the state of flux of understanding point. But that's the underpinning of how we say the ANPS might have been, if made at all, at this point, different. Lord Sales.
Yes.
I follow the point you make on paragraph 631(3) of the Divisional Court's judgment. But the reference to carbon reduction targets and carbon budgets in paragraph 5.82 is presumably to such targets and such budgets as are set from time to time under the Act. Yes. Is that not right?
Yes, and indeed one of the other paragraphs of this exchange makes that clear.
So insofar as, for instance, the CCC comes to a stage where it recommends that there be a tightening up of the targets under the Climate Change Act, those will be the targets to which paragraph 5.82 refers, won't they?
Yeah, absolutely. That's absolutely right, my lord. The question, though, if I just sort of step back in terms of our wider legal analysis, is that we are here seeing this through the prism of section 10.2 and 10.3 of the Planning Act, which, as I canvassed yesterday, specifically is not constrained by the CCA considerations. So the question is, of course, the Secretary of State has made provision for the CCA targets as they float, as it were, as they evolve. But that isn't an answer, and that's the thrust of the Court of Appeal's analysis, to the wider evaluation that is contemplated by Section 10.3. So my lord is right, but it contemplates a number of situations. First, one of which, for example, is that CCA is not keeping up with emerging thinking. I think that's Mr. Crossland makes a deal of that. Another of which is that the CCA simply doesn't embrace the other considerations of post 2050 and non-CO2 effects at all.
I'm so sorry to interrupt you, but under Section 10, why is the government not entitled to follow the advice of the CCC so far as the impact of Paris was concerned, and say, well, things will change in the future, but the CCC does not recommend a change in the various targets that have already been set in order to deal with Paris? Why isn't the government entitled to have regard to that advice under Section 10 as well?
My lord, it is. Can I just take you on that? Takes me nicely to the point I was going to take you to next, which is how matters evolved from 2016. I think was there another hand up? I may have missed one. No. Let me move on to that exact point. And if I don't answer your question, Lord Sells, I know you'll come back to me.
All right, thank you.
So you've already seen some of the October 2016 CCC advice, 1359 in the bundle. I think you saw in particular in the executive summary. This was the point at which the CCC was indeed saying now is not the time, it's too early to change the targets. But they absolutely weren't. If we look to 360, they absolutely weren't saying that the UK was anywhere close to convergent with the Paris requirements. You see that on 1360. There's a slightly confusing set of bullet points and so on, but just above the heading number 2, net zero emissions, there's a paragraph which says, we welcome the government's commitment to ratifying the Paris Agreement by the end of the year. The clear intention of the agreement is that effort should increase over time. While relatively ambitious, the UK's current emissions targets are not aimed at limiting global temperature to as low levels in the agreement, nor do they stretch as far into the future. So it's not just an ambition point, it's also a time reach point. Just to play the time sequence, the chronology through, and I know Mr. Crossland is going to do this in more detail later, so I take it relatively swiftly. The clean growth strategy was in October of 2017. You've got extracts from that at page 1529 and 1530. So this is where we're inching now towards the Secretary of State's understanding of the position when he comes to make the ANPS. You've got paragraphs on page 1529 and 1530, including, for example, at 1530, the top of the page, under the heading Global Temperature Goals and Our Progress Towards them, emphasising that scientific evidence shows increasing magnitudes of warming, increasing the likelihood of severe, pervasive and irreversible impacts. So that was the continuing understanding. And then an explanation on the right-hand column of the evolving targets position. If I can then just pick that all up in the chronology that you have attached to the statement of facts and issues, because there are then some important dates.
Yes. Mr. Wolf, could you just wait one moment? I see we've lost a visual link with Lord Leggett, and I just want to check if he's still with us.
Sorry. Yeah.
Right.
Yeah. Oh,
Apologies for not spotting that.
there we are.
That's better. Thank you.
If I could ask the court to look at page 96 of the bundle, this is the chronology attached to the statement of facts and issues. Picking the dates up on page 96, about 2/3 of the way down the page, in January of 2018. In January of 2018, the IPCC's report into the implications of crossing the threshold of 1.5 degrees global warming was commissioned by governments in 2015. So that's a nod back to the beginning of the process. So from 2015, post-Paris, this had been commissioned. And then we get the important words. The draft report was reviewed by governments around the world between the 8th of January and the 25th of February 2018. And then on the 17th of April, foot of that page, the government announced at the Commonwealth Heads of Government meeting after the IPCC report this year, it would seek advice from the CCC. So that was the, as it were, the external process heading into the making of the ANPS in June of 2018. And so the relevance, the reason I show you that is to give context to the government's concession, Mr. Marici's concession, which is very specific, as Lord Anderson rightly pointed out, but also needs to be understood in its context. The context for it was a pre-trial review conducted by Mr. Justice Holgate, who was at that point dealing with preliminary matters on the divisional court process. You see his email, it's quoted by the Court of Appeal, paragraph 220. I simply draw your attention to that for the moment, because it explains the context in which this arose. So 3 lines down in the quote in 220, the original is in 1833 if you want it. The defendant's concession, if that can be the correct description, or rather helpful of narrowing the issues, arose in the context of submissions regarding applications for disclosure by Friends of the Earth and Plan B. That's a reference to an application for disclosure. We haven't troubled you with all the documents, but we can obviously give them to the court if they're needed. And no doubt Lord Anderson, prompted by Mr. Humphreys, who was there, will correct me if I get the events wrong in my description of them. The government had signposted a possible Section 31 argument, a no difference argument, or high likely make no difference argument. Friends of the Earth and Plan B had responded to that in part by making an application for disclosure of documents within government relating to emerging understanding in relation to the implications of the Paris Agreement in the period leading up to the ANPS. So what was the internal understanding arising from those exchanges with the IPCC process externally? That was a context in which Mr. Marici for the government then in effect said, and I'll show you this in a second, in effect said, we are not proposing, we don't think we need to make disclosure of those documents. The reason being, we are not going to argue that there wasn't material in government that it's highly likely would have not made a difference. Now you've got that you've seen this, but it now may make more sense. If you look at page 688 of the bundle, this is within the amended detailed grounds. It's 687. It actually starts, I think, of the amended detailed grounds of resistance that followed that event. The last 2 sentences on page 687. Last sentence on 687, the claimant's argument put in the above context amounts at their highest to an argument the Secretary of State could, but did not take into account developing areas of climate change policy. There's no error at all in the Secretary of State exercising his discretion not to consider these matters, assuming such discretion existed, and was not in fact impliedly excluded by the terms of the 2008 Act. Accordingly, the Secretary of State will not pursue any discretion argument that there was A, no emerging material within government evidencing developing thinking on the implications of the Paris Agreement, or B, that such material would highly likely to have made no difference to the decision to designate the ANPS. There's no need for him to do so. The argument was obliged to consider that such material in the first place is hopeless and should be refused. So he was digging in his position, obviously entirely properly, by saying that there was no legal basis to go beyond the Climate Change Act obligations. But we won't take a discretion argument. We won't take a discretion argument because we're so confident on that proposition. But we will take that stance as a way of resisting providing the information. But we're not saying there wasn't information that would have led us to a different decision, or might have led us to a different decision had we looked at it. And so, my Lord, in a sense, whatever one sees in the public sequence of events and in the CCC processes, what we have by that concession properly understood is a recognition that internal to government there was emerging thinking that might have made a difference, and that's the critical thing. The question was the Secretary of State right to exclude from his consideration that emerging thinking, as he did on the basis of a legal error? Well, I'm also helpfully directed to paragraph to page 2141 of the bundle, which is in the Plan B judicial review. Paragraph 15 of that gives a further insight into the emerging state of knowledge. Paragraph 15 on page 2141, 4th of June, this is the judgment of the court, the IPCC announced that it sent the final draft of its special report on global warming to government for comment. So what we have is information with government as to the effects of all of those things that was specifically not considered because it wasn't considered to be legally permissible to do so, that might have made a difference to the 2018 AMPS designation decision. So that is the concession, if that's the right word, that was made by Mr. Marici on behalf of the Secretary of State. The reason we obviously say that Lord Anderson's team can't go behind that concession is that they are in the same position that we are, and indeed the court, which is that we don't know the information that was behind the scenes. In a sense, that was the very point of the concession and the way it was put. So, of course, Lord Anderson makes other questions around discretionary relief, but in our submission, it's simply not possible for any of us to go behind any of that because for the very mechanism by which it was given. So that is how we get to the point, and we'll see it shortly in the critical Court of Appeal reasoning, where it is said that the Secretary of State's decision to close his mind to the non-CCA material by reference of his legal understanding that it was not permissible to look at it was fundamentally material here because it might have led him, and that's all we need to get to make an AMPS in different terms. And therefore, an ANPS that might not simply have pegged itself to evolving CCA matters as they evolve in the future, but might have done things differently. And in our submission, it's not for us to, as it were, rewrite the ANPS or for the court to speculate as to what the ANPS might have looked like, because we have the Secretary of State saying, I am not arguing it would necessarily have been the same. And in our submission, that's all one actually needs to get from that point. Now, of course, we have, if you like, the benefit of, 2020 hindsight, and we know that a year or so later, the 80% target was amended to being a 100% target for the 2050 obligation. But several things that doesn't in any way mean that there's been a complete catch-up or that these issues no longer arise, even ignoring non-CO2 and post-2050, even in relation to the CCA implementing the Paris Agreement. One can test that this way. Well, first of all, that amendment was made to the CCA before the case came to the Court of Appeal. And there was no argument before the Court of Appeal by any party that somehow the 2019 evolution of the Climate Change Act meant that by a discretionary relief route or otherwise, the arguments fell away. But even that's not even then a complete painting a picture, because actually, and the court may not have seen this so far, let me just show you it. Even the amendment of the 2019 amendment of the Section 1 target doesn't bring position into line, because what we have is the budgets that you've heard of already, and the Climate Change Act budgets even today have not been updated to catch up with that 100% target. You've got that if you need it. It's in the CCC's advice at page 1856. CCC's advice more recently at 1856. So the position we were in 2019 and indeed still in 2020 is CCA has not caught up. No necessary indication as to when that will be. Put that back then into the prism of the Section 10 question. Was it right to frame the Section 10 question simply around CCA targets that were demonstrably lagging behind, and so as not to include other considerations like non-CO2 and post-2050 that were not part of the CCA evaluation in any event? And as I say, all of that is tied up very fundamentally with the Secretary of State's concession, and that's why that's a very important process. So, my Lords, that's how we get to those points. I mean, just to pick up a little bit more, perhaps finally for now, on how the ANPS might have been different. Not only might it have been framed in those wider terms or not involved that stop-go test, or indeed not have been made at that point at all. The Secretary of State might have said, well, all of this is evolving, therefore I should pause and see how this shakes down. Even in relation to the other factors, it's very clear to see, not for us to prove how it would have been different, burden is not on us, but to imagine how it might have been different. One of Lord Anderson's propositions, for example, on non-CO2 is to say, well, how can you include something relating to something that you can't assess? Well, my Lord and Lady, that's no answer, because you don't need to be able to assess it at the ANPS making stage to be able to build in a test at the ANPS to be considered at the DCO stage. Likewise, post-2050, he says, well, we can't make up post-2050 policy to go into the ANPS. Well, we are not saying that that was a necessary process to do. That's a plainly impossible thing to do. All that needed to happen is that the ANPS didn't cut the considerations down to pre-2050 evaluations. It needed to open them up. Lord Leggatt.
All your arguments are going to put forward some sort of case that there could have been an argument for taking a broader view of what should go into the ANPS. That seems to be quite a hard argument to make, since the government was following the advice that the appropriate basis on which to formulate it was current policy and not future policy. But this is a million miles away, even if you get to this stage, isn't it, from showing that it was irrational to take the view that the government did, which is the view you have to get to, and that any other approach, the one they took, was an irrational one. You're just about getting onto the scoring surface, but it's got to be the only possible view that's reasonable.
Well, can I come to that more, if I may, when I come to the specifics of the ground two arguments? Just to give a signpost to the way in which we put that, and the way in which indeed the Court of Appeal decided it, was that what we see is that the Secretary of State directed himself that he couldn't, that the CCA was effectively the beginning, middle and end of it. He couldn't look beyond that. And therefore he didn't.
But that's just wrong, isn't it? Because in the amended acknowledgement of service, it was made quite clear that the view they took was that not that it was legally impermissible, but that it wasn't an appropriate basis on which to formulate the ANPS. Take other matters into account.
May I come back to that in a few minutes, if I may, when I come to ground one? I will, of course, come back to it. I'll to deal with it in a moment, if I may. I'm not in any sense ducking it, because it's an important point I need to deal with. Can I just, before I move off the exchanges around the matters that arose from the Divisional Court's judgment, I don't want to lose sight of one additional point that arose from that, which is the Divisional Court's judgment, as we saw a moment ago, dealt with the way in which Paris doesn't set objectives that are enforceable domestically, and that's in a narrow sense clearly right. That is also, just to deal with the discretion point that Lord Anderson makes, that's also why it wouldn't be of any assistance in a DCO evaluation around Section 104.4 of the Planning Act, which contemplates the government departing, or Secretary of State departing at the DCO stage from an ANPS because of breaches of international obligations. That doesn't arise in relation to Paris. So that is just to, I just wanted to finish off those foothill points. I'm not, any sense ducking Lord Legate's question, because I'll come to it in a moment if I may. Before I come to those questions, though, can I just deal with one more foothills point, which is this, if I may, which is the nature of the court process as it's evolved through to the Supreme Court, which is that, as the court has obviously seen, the hearing before the Divisional Court was a permission hearing. It was a rolled up permission hearing, which led to the Divisional Court refusing judicial review permission. That then went to the Court of Appeal pursuant to an order of Lord Justice Lindblom, as you've seen, as a completely rolled up process. So that combined a number of steps within it, in other words, application for permission to appeal and so on, leading to grant of judicial review permission, and then leading to a substantive judicial review hearing, all allowed for and contemplated by CPR 52.86 and the related provisions. The effect of that was that when the Court of Appeal came to consider it, it was considering this as what the court has previously called its original jurisdiction to hear a judicial review. So it was not hearing in the end an appeal against the Divisional Court's decision. It was making evaluations for itself. Of course, it had well in mind what the Divisional Court had said, not least because the Divisional Court had considered things in considerable detail. That matters in a sense. The detail, the consideration by the Divisional Court is actually important for my purposes in any event. The reason being that when we come to the Divisional Court's recording of the Secretary of State's position and the Court of Appeal's evaluation of that and its account of the Secretary of State's position, and these are relevant to answer Lord Legate's question, they had the benefit of submissions from Mr. Morici. So the Divisional Court had the opportunity to quiz Mr. Morici to clarify the government's position as it was before the Divisional Court. The Divisional Court then recorded that position in its judgment, and the Court of Appeal had then the benefit of Mr. Morici again in order further to quiz Mr. Morici in front of the Court of Appeal. So two courts heard Mr. Morici, explain and clarify exactly what the government's position was, exactly what the Secretary of State said was meant by the evidence, and therefore exactly what factual conclusions they should proceed from on that basis. My Lord Legate.
But Mr. Wolf, you know very well, counsel can't give evidence.
My Lord, I'm not saying he was giving evidence. What I'm saying is that he was clarifying for the purposes of the court, and the court reached appropriate conclusions on the basis of that, how the court should understand the materials before them. And particularly when one has the Divisional Court setting out quite crisply propositions from Mr. Morici that were then available for and indeed were the subject of exchanges in the Court of Appeal. My Lords, this
we can read what they say for ourselves. It's not very complicated to read the acknowledgement of service. We've got the document. We don't have to go to what Mr. Morici may have told the Divisional Court it might have said.
Well, my Lord, and I can only make the submission, which is this, which is that in my submission that it wouldn't be appropriate for this court to go behind, or for only to go behind in exceptional circumstances, what those courts have done by way of evaluation of the Secretary of State's position as it was explained to them, particularly in circumstances where, as I'll show you shortly, the Divisional Court recorded the position, and then the Court of Appeal had the benefit, obviously, of that judgment, and then restates the position by reference to the Divisional Court. So it's absolutely plain, and indeed it was plain at the time, that those matters were absolutely live in the exchanges. You don't have the benefit, this court doesn't have the benefit of Mr. Morici to deal with them, and that's the context for our submission, that this court should be extremely slow to go behind those conclusions. Lord, there's been no, if they were, as it were, counsel speaking out of turn, there was no attempt between the High Court and the Divisional Court and the Court of Appeal to say you got it wrong, you misunderstood me, and there's been no point since then, no attempt and no request by the government to take part in these proceedings to clarify that, even if to take no other part, to deal with the position. Lord Sales.
Yes. You're talking about Mr. Morici's position again in the Divisional Court, and we touched on this yesterday. I think the relevant paragraph is 638, which I think is page 417 in the bundle. And to my eyes, makes it very clear that Mr. Merici was running two arguments. One was a pure legal argument that, as a matter of law, the Secretary of State could not have regard to the Paris Agreement, and that failed. But one can readily understand why Mr. Merici was running that, because if he won on that point of law, then he won on this issue. But his second argument, and it seems to me very clear that it was a second alternative argument, was that even if the Secretary of State was not obliged to ignore such commitments, he had a discretion to leave them out of account, and he exercised that discretion.
Right. Well, Lord, it's the last bit that I think is problematic.
Sorry, it's not problematic so far as I can see in understanding what the position adopted by the Secretary of State was before the Divisional Court. That then leads into direct reliance, as I understand it, by the Secretary of State on what had been set out in the amended detailed grounds, which in itself reflected underlying evidence of Ms. Lowe and Ms. Stevenson. It just doesn't seem to be even particularly complicated. The Secretary of State was running an argument that he was entitled, in the exercise of discretion, not to have regard to the Paris Agreement for these purposes, and that he had exercised that discretion via his officials.
My Lord, the reason that we bulk at that characterisation is this: what the Secretary of State was identifying, and indeed what the Divisional Court identified, what was step one, an understanding that it's precluded by law. In other words, CCA precludes wider consideration. Step two, if that is wrong, then the Secretary of State has a discretion. And then it's step three that's problematic, which is, and that he exercised that discretion unencumbered by that legally erroneous view. And that's what we don't get. So I think Lord Anderson put it as a fallback. One can understand as a lawyer, somebody can say, I don't think I can do this, but even if I can, I wouldn't want to anyway. In other words, a second stage contingent assessment. My Lord,
forgive me. The evidence of the witnesses and what is said in the detailed grounds doesn't say the basis for our exercise of discretion was that it was legally not open to us to have regard to this. But the whole point of what is said in the evidence is that there was an acceptance that they might have had regard to it, but they could look to actual reasons why they didn't think it was a good idea to have regard to it. Now that's not compatible with them having been advised they're not allowed to have regard to it.
Well, when we come to their materials, they use language like appropriate, and certainly the way the Court of Appeal has understood that, in the light of hearing the submissions from Mr. Merici, and I will come to it in a moment. I'm not running away from it. Is that what they were reflecting was a legal understanding. They weren't reflecting, as if you like, a two-stage process, which is the lawyers say we can't, therefore we're not going to. But even if the lawyers said differently, we wouldn't for the following reasons. That's simply not, in our submission, what their evidence said, and that's not what the Court of Appeal concluded. The Court of Appeal took the view that it was flawed at the first stage. Lord Legger.
Lord Sales is right, isn't he, Mr. Wolfe, that when you look at how Mr. Merici's argument is recorded, he was making a legal submission as his primary ground, as an argument of law that it's not legally permissible to have regard to the Paris Agreement. He wasn't giving evidence as to what the view the officials had taken at the time. Well, it was doubly inappropriate, partly because what legal advice they got was privileged, and he was in no position to waive it.
Well, my Lord, can I come in a moment to the way the Court of Appeal dealt with that matter, because it didn't simply deal with it did refer to, and I'll show you in a second, what the Divisional Court had said, but that it didn't simply, as it were, lift that and draw extravagant conclusions from it. It looked at it precisely in the context of the evidence, which is what I was going to show you shortly.
Well, we could look at that, but the starting point for the submission you made to us was that Mr. Merici conceded or put a gloss on the evidence in the Divisional Court and said that there'd been advice that it was impermissible to take account of the Paris Agreement. But in fact, when you look at what he said no such thing. He made a legal submission. Do you accept that?
Well, he did make a legal submission. So I think I'm being very dim. He did make a legal submission, but the legal submission was as to the basis on which the Secretary of State had proceeded, rather than as it were, a legal submission in the context.
Well, that's a factual submission as to the basis on which the Secretary of State proceeded, and that was his second point, which was the discretion point.
Well, can I show it to you in the Court of Appeal? Because they look at that, they have the benefit of that, whatever one makes of it, and they have the benefit of Mr. Morici giving further submissions to them in the context of the witness evidence which they then look at. I'll come to that in a moment if I may. I'm conscious of time, my lord, so I need to get to that point before too long. My lord, those are my introductory points. Can I then go to ground two? I'll leave obviously Mr. Crossland to deal with ground one. Ground two, which deals with the way in which the Paris Agreement wasn't factored in for Section 10 purposes in the making of the AMPS. My lords, we do take here a procedural rigour point. Can I just remind you of Hal's application, the appellant's application for permission to appeal? It's at page 25 of your bundle. This was their application for permission to appeal, lodged barely a matter of hours after the Court of Appeal's judgment was made public. And at paragraph 19 on page 25, this is their argument under ground two. In discharging the duty under section 10.3a Paris to have regard ... The Paris Agreement was not a mandatory material consideration, nor was it a consideration to which a rational Secretary of State was otherwise bound to have regard. So their complaint was only focused on what the Court of Appeal had said about Paris being obviously material. We responded to that in our obviously permitted response, page 40 of your bundle, paragraphs 10 and running on. This was our response, our objection to their application for permission to appeal, in which we set out at paragraphs 10 to 12. And paragraph 11, we set out what the Court of Appeal decided. 2 steps to that. Whether it was an error of law for him not to ask himself whether he should take into account Paris for Section 10 purposes, or whether, if he'd done so, the only obviously reasonable answer was that it was an obviously material consideration. We said at paragraph 12, in terms, Hal challenges only the second of those, saying nothing about the former. Accordingly, Hal's ground 2 offers no overall assistance in undermining the Court of Appeal's overall conclusion. Ground 2 is doomed on that basis alone. Well, those were the documents on the basis of which, at page 62 of your bundle, this court, or a panel of this court, gave permission for the appeal. So simply in terms of the scope of the issues before this appeal, and you'll see in terms of the way that the issues are framed in the statement of facts and issues, they are quite obviously bounded and expressly bounded by the grounds of appeal. There is no permission to appeal. There's no permission to run the argument to challenge that conclusion, and Hal didn't seek to do so, nor have they sought to remedy that, nor indeed did Lord Anderson say anything about it one way or the other in the process. Lord Sales.
I confess I'm having some difficulty following this. If you go back to page 25 and what Hal was saying, surely Hal are making the point that the Paris Agreement was something which the Secretary of State could, in his discretion, choose not to attach weight to. That's the significance, isn't it, of saying it's not a mandatory material consideration. So you're not absolutely required to have regard to it, nor was it a consideration to which a rational Secretary of State was otherwise bound to have regard, which is the Wensbury test. You've got a discretion, but sometimes it's so obvious that you have to exercise the discretion in a particular way that you have to have regard to it. So surely the whole point of paragraph 19 is to say, this case does not fall into either of the extremes, i.e. mandatory relevant consideration or Wednesbury only one rational view position, it falls in the middle, where the Secretary of State had an open discretion whether to have regard to it or not, which he exercised not to have regard to it. That, as I'm reading that, that's the whole point of ground 2.
My Lord, but that ground has to be seen then in the context of what the Court of Appeal said at paragraph 234, where the Court of Appeal made a specific conclusion, which is the point I touched on and we'll come back to in a second, that he never asked himself the question. The way the Court of Appeal...
234 is simply recording your submission.
235 then says we accept those submissions in essence. So read them together. I'm sorry if that's taking it shorthand. So those were the two steps in the conclusion, and they have to be understood. We say in the round, which is this: what the Court of Appeal concluded, and it explained that conclusion. I'm going to take you in a second to its explanation for the conclusion. That he never asked himself the question. That was its conclusion on the evidence in the light of the submissions before it. He never asked himself the question. And then in effect, limb 2 is to say, but even if he had done so, it's a hypothetical fallback. Even if he had done so, there would have been only one rational answer to it. And so there is a finding there in our submission by the Court of Appeal, reading 234 and 235 together, that he didn't ask himself the question, and that finding was not part of the appeal. The ground 2 challenge, whatever its merits, goes to the second limb at 234, which is the obvious materiality point. But we never get the obvious materiality point because there is simply nothing before this court to challenge the first step.
Right, but I was understanding you to be making a procedural point based on paragraph 19 of the grounds of appeal at page 25.
My Lord, we are.
I have to say, well, I'll stop speaking in just a moment, but speaking for myself, it seems to me clear that in paragraph 19, Hal were very definitely intending to raise the very point that they're arguing before us now.
Well, I won't take time on it. We simply say paragraph 19 only goes to limb 2 in 234 read with 235. It doesn't give them an appellate basis to reopen the essentially factual question that was the Court of Appeal's conclusion in 2351. Well, I won't take any more time on it because I've got other things I need to do.
Can I just ask one last question on that? Why do you say Hal refer to it not being a mandatory material consideration?
Because that is the essence of the second limb 234 sub 2. That is the essence of that question, which is what in effect from the Court of Appeal's analysis, in terms of our submissions to the Court of Appeal and the Court of Appeal's analysis, was a theoretical proposition. In other words, he didn't ask himself the question. That's step 1. But had he done so, let's hypothesize that he'd done so. What would there have been any other answer? To which the Court of Appeal said not. And
I'm so sorry, Mr. Wolf, but surely that's the point of the second limb of paragraph 19
exactly.
on page 25.
Exactly.
I was asking you why, on your theory of what this means, did they even refer to it not being a mandatory material consideration? See,
because
the way I read it is that they were deliberately mapping out the two sort of ends of a spectrum where the Secretary of State wouldn't, in practice, have had any discretion at all. Either it's a mandatory material consideration, so he has no discretion, or it's one of those cases where you can only exercise your discretion one way.
Right, my Lord, in our understanding of the legal position, those are two different ways of essentially making the same point, and it's the point which the Court of Appeal puts by reference to the language of obvious materiality. Those are all just different flavours, different descriptions for the same proposition. My Lord Leggett,
this is all rather fatuous, isn't it, Mr. Wolf? Because if it wasn't as clear as it should have been, the grounds of appeal, you know perfectly well what the argument is now. You're not prejudiced in dealing with it. And if there's a technicality, the grounds of appeal had to have another sentence added in, it'd be neither here nor there to the substance of this appeal.
Well, I don't want to take more time on it, my Lord, because I've only got limited time. So I do want to move on, and I do want to deal with the substance of it. But we do maintain the position that it's not live before this court. But my Lord, can I just add one more point? Which
which is we do have an agreed statement of facts and issues.
Indeed.
And in paragraph 67, it tells us that the Secretary of State's approach to the Paris Agreement is recorded in Ms. Lowe's first witness statement, which is then quoted. And we can read what's said.
Absolutely, my lord. And I'm going to take you in a second to how the Court of Appeal understood that in the context of the other documents.
Well, it doesn't matter. Well, we'll see. At the end of the day, it's for us to, if that's the agreed witness statement, we can read it ourselves.
Well, that's simply telling the court, as a matter of fact, that this is the witness statement, and obviously that's as a matter of, as it were, public record. That's the position.
Well, it's telling us that is an accurate record of the Secretary of State's approach.
Malad, can I come to how that needs to sit in the other materials in a second? I'm conscious of time, and I'm
right. Okay.
My lord, in terms of the way the Court of Appeal dealt with this, which in our submission is critical here. If we pick it up, if I may, in the Court of Appeal's judgment at paragraph 185, just as the foothills for these matters, 185, 186 in the Court of Appeal. They first in 185 remind us of the Paris position, and then at 186 they say this, they record the position. It is common ground that the Secretary of State did not take the Paris Agreement into account in the course of making his decision. So that's their record of the common position, not demurred from. Then at 252, we were getting here a second ago. That they pick up the same point again. This is in relation to this next ground, but they pick up the same point again at 252. This is where they specifically refer back to the divisional court point. Earlier in its judgment in paragraph 638, the court noted that the Secretary of State accepted that in designating the ANPS, he took into account only the Climate Change Act carbon emission targets and did not take into account either the Paris Agreement or any other post-2050 target. I'll come back to that point in a moment when I deal with that argument. But that is the Court of Appeal, as I say, specifically carrying forward, in the light of the submissions they've heard, what they draw from para 638 of the Divisional Court. Back then, if I may, to where the Court of Appeal explains its reasoning on what is now ground 2, but was then climate change issue 1. This is para 236, 2, 3, 4, 5 and 6. We've seen 234 and 235. Where the Court of Appeal accepts those submissions, in other words, what's set out in 234, 1 and 2, and they pick it up under 2 strands, and that's the 2 strands that deal with the 2 limbs of 234, 1 and 2. First, they say, it is clear from the material that was before the Divisional Court, the Secretary of State was advised he was not permitted as a matter of law to take into account the Paris Agreement, because he should, for relevant purposes, confine himself to the obligations set out in the Climate Change Act. Just pausing there for a second. So that they are not merely recording that this was a legal submission made to them by Mr. Morici, as it were, advocate in court, saying what the law is, but that was the basis upon which the Secretary of State had been advised and proceeded. And
but what if that is simply wrong? I mean, it's not what's said in the 2 witness statements given by the officials, and in our SFI, the contents of those statements, the relevant passages, are agreed as recording the Secretary of State's approach.
Well, they record the Secretary of State. They do. And can I just take you, if I may, to the 2 paragraphs that they refer back to, because they in their reasons they identify the base on which they reach that conclusion at 218 and 220.
And they seem to have got confused between legal submissions and discussions between the judges in the Divisional Court and counsel for the Secretary of State, and treated those as the basis of making a factual finding, rather than paying attention to the witness statements put in by the Secretary of State's officials.
My Lord, can I just pick up those points, if I may, as I go through? I am conscious of time. The paragraphs to which they refer are back in their own judgment at 218 and then 220. 218 is picking up from the amended detail grounds. So this is the Secretary of State's amended detail grounds, which are signed off and take effect as evidence. So they're not merely an abstract legal document, they're signed off and take effect as evidence. 61 in the quote, there's no credible basis for suggesting the obligation in 10, 2 and 3 in some way extends further than 5.8. That was because we were disagreeing with Mr. Crossland on 5.8. Rather, and then this is the bit they underline, those provisions provide a very strong pointer that matters should not be considered. The clear intention of Parliament being that such consideration should be given only to existing domestic legal obligations. Then they pick up over the page at 220 the matters arising from the pre-trial review, and in particular, in the closing words of the extract on page 297, they say this in the last 3 lines in the quote. The indication given for the defendant at the hearings, this is Mr. Justice Holgate recording the position, was that insofar as the Paris Agreement differs from the 2008 Act in any relevant significant way, then the matter was not taken into account. So that's, of course, recording the defendant's position, but not resolved from by the defendant. Then they go on in 221 to say it's been made clear before this court, both in writing and in oral submissions, that the Secretary of State does not take any point under Section 31 of the Senior Courts Act. It follows, therefore, that the Secretary of State accepts that if he erred in law and failing to take into account the Paris Agreement before designating the ANPS, it cannot be said it's highly likely the outcome would have been substantially the same in any event. If the court does reach that conclusion, therefore, which it did, the Secretary of State, but not how, accepts there be no reason to deny the claimant's appropriate remedies to give effect to the judgment of the court. So, look, that is the basis on which they put together the Secretary of State's position to understand it. I will come to the witness statements in a moment, Lord Sales.
Well, I was going to say that, well, what do you say to the comment that it seems most unfortunate that the Court of Appeal didn't actually refer to the witness statements that set out the true factual position? You've shown us what they have set out by way of their consideration of this, but they don't go to the witness statement. Is that not rather strange?
My Lord, they do. They pick that up starting at, it's at page 69, sorry, paragraph 196 of their Court of Appeal. They have a heading which says relevant evidence, and that begins the sequence. So they absolutely do pick up the evidence.
All right.
Page 4, so it's 458 from Ms. Lowe, which I think is possibly the passage that one has in mind.
I see. Yes, thank you.
And they specifically analyse exactly what she said and the basis on which she said it in detail. And they say this: in October 2016, the CCC said, and then 5 lines down, and I'm going to take this fairly quickly because I'm under pressure of time, I'm afraid. Furthermore, the CCC acknowledged, in the context of separate legal action brought by Plan B, the Secretary of State for Business, here in footnote 111, it's possible the existing targets could be consistent with the Paris Agreement. Subsequently, in establishing its carbon obligation for the purpose of assessing the impact of airport expansion, my team has followed this advice and considered existing domestic obligations. So they then go through, sorry, Lord Sales.
Well, but the advice being referred to there is the advice of the CCC, isn't it? Not legal advice.
My Lord,
so I might it not be said that this evidence is in fact only consistent with the Secretary of State's officials considering that they had a discretion and then wondering how to exercise that discretion, and in doing so, having regard to the advice of the CCC, which they thought gave them reason. They might have been wrong, we can consider it, but they thought gave them reasons for not bringing the Paris Agreement into account at this stage.
Well, my Lord, that is why in the Court of Appeal's analysis of this evidence, in my submission, a careful analysis, they precisely pick up, they underline the section disadvice, and they've identified footnote 111 in the document to which they're referring as being the provenance of that advice. And they then follow through that, and this is paragraphs 197, 198, and so on. And I won't take you through all of the detail of all of that. Because what we get to, that's effectively the pleadings in the Plan B judicial review is referred to. And then when we get to 201, having looked at those materials, nevertheless, this is 201, as is apparent from the terms of paragraph 458 in the witness statement of Ms. Lowe, the document was treated by her and her team as advice from the Committee on Climate Change. As is also clear from 458, Ms. Lowe and her team clearly regarded the existing domestic legal obligations as being the correct basis for assessing carbon impact of the project. We do not think, however, this necessarily followed from the Climate Committee, what the committee was saying in its response document. And then they set that out and they explain in 202 and 203 why that's not the case. So, my lord, they absolutely deal with.
Forgive me. Can I just ask on 201? Shouldn't the question have been whether it was a possible rational view for the officials to form of the CCC advice that is what they were saying, rather than asking whether it was something that necessarily followed from what they were saying?
I'm sorry, I may not be following my lord's question. My reading of what the Court of Appeal is saying is that the Secretary of State's officials followed the CCC's advice as moderated, see footnote 111, through their response to the Plan B appeal, which was a slightly odd way of doing it, but that's how the Secretary of State explained the position, and that was setting out a legal position, which the Court of Appeal then goes on to say was a wrong legal position.
I mean, is there not a clear error in paragraph 203, but where they're saying fundamentally, even if the targets in the Climate Change Act were consistent with Paris, it didn't follow as a matter of law that the government was precluded from taking into account the Paris Agreement. Well, nobody, as far as I can see in government, ever have thought that they were precluded from taking this into account, that they were acting on the advice of a committee to the effect that the Paris Agreement didn't justify any alteration in existing policy at that stage.
My lord, the point my lord makes, what the government advice was, that is not the submission that's made by Mr. Morici, and it's not what the government set out in its case, including to the Court of Appeal, which they explored with him. If we look at page 563, which is the Secretary of State's skeleton to the Court of Appeal, it may be surprising, but it was indeed the government's position that they had proceeded on the basis of legal advice that said CCA 2008 precludes wider consideration for Section 10 purposes. That was their position, and the Divisional Court of Appeal are not wrong to conclude that. We see in 182 to 184 on page 563. The context described above, I don't think we need to see that just for now, provides further strong support for these submissions that Section 10.3 instead requires that regard should be given to nothing other than existing climate change policy provided for by the CCA 2008. Then in last four lines in 183, Parliament has thus provided careful and detailed mechanisms by which climate change policy be established. The clear implications is that this carefully crafted policy requires the Secretary of State to consider when formulating an MPS. 184, there is no credible basis for suggestion that the obligation in Section 102, 103 goes further than Section 58 in the sense of mandating consideration. Rather, those provisions provide a very strong pointer that such matters should not be considered. The clear intention of Parliament
with legal submissions. Sorry, Mr. Wolf, we're back with legal submissions here, aren't we? And we've gone away from the factual position. And the whole confusion seems to be in treating what was a legal submission as if it was evidence of what had been decided at the time. Well, this was an argument of law made by Mr. Morici.
Well, my lord, it wasn't presented as being an after the event argument of law. In other words, that wasn't their legal understanding at the time, and that's what the Court of Appeal and the Divisional Court were able to test him on. And the Court of Appeal has set out, and I don't think I've got time to go back over.
When you present arguments of law, you're not presenting them as necessarily the advice you gave to your client or the advice you didn't give to your client. They're just the submissions you're making to the court.
Of course, that's the general position, my lord. But the situation here is the two come together. The two come together in the way the Court of Appeal has explained it. And I haven't got time to go back over that. In the way the Court of Appeal explains it, they draw that from effectively three different sources. First of all, what the Divisional Court recorded, Secondly, the documents before them, including legal documents like the skeleton argument and so on, but all of those, as we know, are carefully approved by government legal department, and also the submissions they then receive that they are able to test. So that's why we do say this court is in the position of a classic appellate court, which in our submission, tempted though it may be to interfere with that finding of fact, in our submission shouldn't do so, because the Court of Appeal had the advantage of hearing all those materials and precisely testing the point that this court is now putting to me, which I can't really assist you with because I'm not Mr. Morici, and Mr. Morici is not here to assist us. But rather like a witness in a trial, he was there to assist the Court of Appeal, and he did so, and that's the conclusions that they drew. Because I don't think I can to take that further. You've got the materials there, and you've got the Court of Appeal's explanation for how it gets to that point. My Lord, the appellant points to two other sources of information on this. One is Ursula Stevenson's witness statement, which you have at page, or the extract of which you have at 824. Where this is paragraph 3.128 on her witness statement. She picks up the approach that was taken in the AOS, and she simply refers to, and if you like, piggybacks on, please excuse my vernacular, piggybacks on what Ms. Lowe says, so she doesn't add anything. And then the third, I think that the appellant identifies is a paper to the Cabinet, which is at page 1610, or the extract is, well, the beginning is at 1610. The relevant extract, the relevant paragraph is paragraph 100 of that, which is, sorry, my reference is incomplete, which is at 1620 running into 21, paragraph 100. Well, that simply explains the government's position on international obligations and so on. It doesn't actually say anything at all about the decision-making approach. It's simply a statement of, as it were, external position. So, my lords, I don't think I can go any further than to give that. Sorry, my lord, Lord Sales.
Yeah, I'm so sorry to pick you up on what you said about Ms. Stevenson's evidence. You said she added nothing. She gives direct evidence as one of the relevant officials of how she approached the matter. That's not adding nothing. That's her directly giving evidence as a relevant official as to how the Secretary of State approached the matter.
But what she says, my lord, just to go back to page 825, top of 825, is she says the AOS has followed this advice.
Yeah, and she was one of the officials responsible for pulling the AOS together.
My lord, absolutely, and that's a very carefully, if I can put it this way, very carefully crafted sentence. The AOS is indeed consistent with that advice. It has indeed followed that advice. She is not saying this was the base on which we considered it. And indeed, I'll show you in a moment when I come to the SEA argument, that couldn't have been the case because the AOS scoping evaluation was done before the CCC had even spoken. So she can't, and I'll show you this in a moment, she can't be speaking about the approach taken in the scoping process by reference to something happened in October 2016, because the AOS scoping was done in March of 2016. So all she's really doing is saying it's consistent with what the CCC had said. She can't be saying we scoped the SEA by reference to things that hadn't happened.
But she's not talking about the scoping. She's talking about the final production, the final AOS as produced. The timing fits perfectly, and she's saying, when we produced the final AOS, we followed the CCC's advice. Forgive me, it seems very clear what she's saying.
The framework for the AOS was set with the scoping exercise, which I'm going to show you in a moment. And there's no suggestion anywhere that was revisited in a scoping sense in the course of that process.
I see. Thank you.
My lords, my lady, the second limb of the Court of Appeal on this ground is dealt with. So this is back to page 299 of the bundle, paragraph 234 sub 2, which is the obviously material point. we accept, as Lord Anderson describes, and indeed as the Court of Appeal put rather more pithily, the structure of public law decision making, and that one gets in the end to a category, call it the third category from Lord Brown in Hurst, if you like, that says, is this an international agreement that is obviously material, notwithstanding it's an unincorporated agreement? And the Court of Appeal said, yes, it is. We say they were entirely entitled to say that. We set out in our statement, in our case, we give you a reference to what Lord Carnworth said in the Sam Smith case. This is 2269 para 32 in your bundle. You also have, not mentioned by us, but mentioned by Lord Anderson, the DSD against the Parole Board case, Court of Appeal case. That's 2852 paragraph 137. And that's the Court of Appeal talking about the question of obviously material. And they say whether it's obviously material to a decision on a particular project. Both of those are emphasising the context-specific nature of the evaluation. And again, we say the Court of Appeal was in a good position to evaluate that, and this court shouldn't interfere with it. The point in the end, and I trailed this yesterday, is an extremely simple one, which is in the context of we're not here talking about a general, shall I take into account Paris for the purpose of the ANPS? It's not a general open textured question. It's a question being asked in the context of the Section 10.3 obligation, which is a specific mandatory focus on the desirability of mitigating climate change. So in the context of specifically asking about the desirability of mitigating climate change, we say it's absolutely obvious that it would be irrational to leave out of account the Paris Agreement. Once you recognise that you are not constrained by the CCA, of course, if you're constrained by the CCA, then that's a different question, but that's the first step, that's the legal right or wrong approach. Once you get to the second step and say, here I am asking myself about the desirability of mitigating climate change, in an open textured way, the very agreement which was executed recently, which has been ratified recently, and which is in train and is agreed on the international sphere and indeed behind the scenes to up the escalation of the desirability of mitigating climate change, we say, and the Court of Appeal said, is obviously material. And it wouldn't be rational, wasn't rational, if there was consideration of it at all, to leave it out of account. My Lord Legate.
You can say as many times, you can keep saying, like the Court of Appeal did, it's obviously material, but they didn't explain why. Yeah. And I asked you at the end of yesterday, you said you'd come back to it today, to say why it was so blindly, obviously material, which requires you to point to some specific point in the Paris Agreement that any rational person would have appreciated made a difference inevitably to the appropriate policy statement.
Well, my Lord,
you haven't pointed to anything that's arguably irrelevant yet, as far as I can see.
My Lord, the Court of Appeal explained, and I don't think there's any dispute in this court, that the Paris Agreement increased the desirability of mitigating climate change. Lord, that is riddled through the CCC documents, including some of the ones I showed you this morning, and I know Mr. Crosland is going to show you more.
Yeah, but if a government already has world-leading targets on emissions, then, and this is a global agreement, Paris, unless it affects the UK targets, how does it have any bearing on anything?
Well, it bears, let me, at the risk of repeating myself, just remind that the statutory question is, what is the desirability of mitigating climate change? And that's a freestanding question as a matter of construction of the Planning Act and the CCA 2008. It's a freestanding question from what are our targets? It's an open question which Parliament has required the Secretary of State in making an ANPS to ask him or herself. And when one comes to ask that question, if one was constrained as a matter of statutory construction by the CCA, well, that would be a different question, but one isn't. We know that.
But the domestic decision-making process must take as its starting point a decision as to what are appropriate emission targets. Once you know what those are, it's then a matter of policy for government as to whether you achieve that by restrictions on aviation or restrictions on industry or motorists or whatever it may be, or how you balance these things. Those are the policy issues that then arise. But the advice from the CCC was the Paris Agreement doesn't entail any changes in targets as matters stand.
My Lord, the Secretary of State wasn't constrained by the CCC's advice, and that's why the concession element is so important. In responding to the concession and in resisting the disclosure application, he specifically recognised that there was material within government, post-CCC material, emerging in the context of the IPCC's international deliberations, which might have led him to reach a different answer. So the clock doesn't stop with what the CCC had been saying in 2016. It evolves right through to the spring of 2018, which is why I showed you those documents, and which is why I emphasised that those were the entry point into disclosure applications. So that is all entirely and necessarily bound up with what one's understanding of what the position was behind the scenes, and we can't go behind the scenes because of the disclosure resisting within government, and that's why the concession is so fundamental to the whole legal understanding, if you like, because if there had been if the CCC had been the last word on it and there's nothing else that could be said, well, one might say, well, that's the last word on it can be said. But here is material internal to government which the government accepts in responding to the disclosure application might have led them to a different ANPS, which they...
Well, you say that only because they didn't actively contest the fifth ground of appeal, as I understand it. I mean, that's not a concession.
I think, does my lord mean the disclosure application?
No, I was meaning, as I understand it, it's because the government didn't seek to argue that any error by them made no difference, that you read that as a concession that if there was any error, it did make a difference.
No, well, my lord, we don't need to go that far because the burden in the Section 31 argument is on the defendant. All we say is there's an acknowledgement of material internal to government in that period, in the early part of 2018, post-CCC's published materials, which might have led to a different ANPS. So that's why we say simply following the CCC's advice of previous years was not enough. What we had is we had emerging material on Paris, which showed its greater ambition, which we say, and the Court of Appeal said, was therefore obviously material and needed to be taken into account. I'm not sure I can take that any further. It's the leaping off the page point, and it follows from the fact that even as the CCC was advising, Paris had greater ambition than existing targets.
It might leap off the page. I mean, it's a global agreement. It might leap off the page if you were one of the world's more heavily polluting countries. Although, in fact, it does, because when you read it, it makes all sorts of allowances for countries like China and India because they're allowed to continue economic expansion. But it's hardly going to make an obvious difference to a country which is already making a leading contribution to avoiding or limiting global warming.
Well, those would be the sorts of my lord mentioned a moment ago, the balances around aviation or cars or whatever it might be. Those are the policy evaluations which the Secretary of State would take into account, having properly addressed himself to the statutory question which was put before him by the Planning Act of what is the desirability of mitigating climate change. Because what Parliament has specifically framed is to say, through Section 10 read into Section 5 of the Planning Act, when you make or review an ANPS, you have to have regard to the desirability of mitigating climate change. That is an open question, an open textured question. And in the context of having regard to the desirability of mitigating climate change, to then formulate your policy, which is the point that Lord Reid is rightly putting to me, you have to get that first step right. You don't do the, if you like, economic evaluation or whatever it might be in the first step. You have regard to that desirability as an open statutory question, and that's what Section 10.2 and 10.3 are telling you. Well, I am going to have to move on given the time. My lords, can I then pick up the SEA point, which is ground 3? You have this within the Court of Appeal at paragraphs 242 through 247. the Court of Appeal rightly, and I'll show you why I say this in a moment, referenced this entire consideration, picking it up at paragraph 245, to the question of what is relevant, that matters, and it matters a lot, because the Court of Appeal had set out earlier in its judgment, this is at paragraphs 50 to 61, I'll perhaps ask you to just turn those up very briefly, had set out the relevant statutory provisions relating to SEA, including at 57, 58, and so on. And there are two steps to this process. There are very much two steps. The first step is a what is relevant, and the second step is a what is reasonably required. And the SEA directive very carefully crafts those out. And the relevant question arises if we look at paragraph 58 of the Court of Appeal. This is in the mandatory information to go within the environmental report. At little e, which is the top of page 244, the environmental protection objectives established at international community state level, which are relevant. So that is a pure relevance question. That's step one. And then step two, Article 5.2, in terms of the information on those things, you're required to put in what is reasonably required. What is reasonably required? Having regard to a number of factors. Now, that matters because the Secretary of State's analysis of all of this was entirely focused on the relevance question, not on the reasonably required question. That matters because Lord Anderson's critique is in relation to the second of those, which is a much more open-textured one, and I'll show you that in a moment, if I may. In terms of the Secretary of State's case, can I just show you the way the Secretary of State put it? It's in his skeleton argument to the Divisional Court, which is at page 542. Page 542. (192) paragraph 2. The obligation is to have regard to relevant international environmental protection objectives. Ms. Stevenson's first witness statement explains why the AOS did not regard the Paris Agreement as relevant. And then there's a footnote 101. And I'll take you to those materials in a moment. But the question being addressed was, is this relevant? And I'll show you it in the contemporaneous materials in a moment, not was it reasonably required, which is step 2. Footnote 101 takes you to a pleading, which I won't take you to, and then, as you see, paragraphs 3.125 to 3.128 in Ms. Stevenson's witness statement, which, as it happens, we were looking at a moment ago. The simple point there is that that is an analysis of relevance, and we see that also. I mentioned the AOS scoping report before. We see that within the AOS scoping report. If I go, please, to 1301 is the beginning of the scoping report. But the same framework then appeared later in the actual AOS itself. So this is March of 2016. Within that, at 1313, at paragraph 2.2.2, the scoping report refers to, quite properly, what we've just seen, which is the requirements of Annex 1, including Lim E, relevant plans, programs, and so on, relevant international obligations. It then sets those out, just jumping ahead, in a table at 1344. This Appendix A is the table. And within that table, if you go to page 1345, running on to 1346 in your bundle, is Appendix A2, Airports Policy - Environmental. And then under that, it says international. And in that list, which is in a slightly odd order, but in that list, you will see, if you look down, the best way for me to direct you to it is to look at the page reference numbers on the right-hand side, because it's an index, is to look at the reference to page 45 and the reference to page 49, which are respectively to the Kyoto Protocol and to the UN Framework Convention on Climate Change. So those are both relatively old at this point international agreements on climate change within the wider list of relevant international obligations, but no mention there or anywhere else of the Paris Agreement. Now, what the Court of Appeal then said, and I'll come to this in a moment, was in this context, the Paris Agreement was obviously material. Part of the understanding for that, we need to look at the Court of Appeal's decision. If we look then at page 300, paragraphs 242 running on, the first proposition is 243 and then 244. And again, this is recorded as a submission from me and an acceptance of it. 243, Mr. Wolf submitted that the reference to international in Annex 1 to the SEA must include unincorporated international agreements, because otherwise, if an agreement had been incorporated to either EU law or domestic law, there would be no need to refer to it at the international level at all. Mr. Wolf also emphasised that what has to be taken into account are the objectives established at international level. This does not necessarily have to consist of particular precise legal obligations. We accept those submissions. Now, none of that is challenged by Lord Anderson's clients. So what we have then is a list for SEA purposes of the relevant international obligations, including unincorporated obligations by a matter of legal reasoning. Included within that list are the Kyoto Protocol and the UNFCCC, which are by this point relatively long in the tooth, but not last year's or the agreement from the other year agreement, which is Paris. And that is the context in which we say entirely correctly, the Court of Appeal says Paris was obviously relevant. Now, that matters. The reason that matters in terms of our overall submissions is that that is a completely parallel way to the Section 10 route, in which the Paris Agreement would have fed in as a mandatory consideration, the Secretary of State's consideration. So this arises entirely independently of any argument on ground 2 about Section 10 of the Planning Act. It's an entirely freestanding way in which the Paris Agreement should have been part of the Secretary of State's thinking, which it wasn't, as we've seen. And had it been, as we've seen, the Secretary of State wasn't taking a point to say the AMPS would necessarily have been the same. And that's the fundamental legal flow that follows through all of this. So, my lords, it's an entirely separate argument, as I say, to anything to do with Section 10 evidence and so on. It simply arises on those matters. And that's the way it works. The way the appellant responds to this is to respond, as you heard Lord Anderson, to talk about and their case, paragraph 62 and thereabouts, deals with it this way, is to ask the question of whether this was reasonably required. Now, I won't go back to that. That's a completely separate question, which arises when you come to then say, how much information do we need about this topic? What do we need about whether it's, let's say, air pollution or noise or water pollution or whatever it may be? That's an entirely separate question. And when we then look at the legal materials that are relied on by the appellant on that point, that they make the point, I'm sorry to be taking this quite quickly, but I'm aware of the time, in their statement of the case, that's a good place to look at it. It's page 136 of your bundle. They make the point in there about what the Court of Appeal had said about how the court approaches the efficacy, if you like, of an SEA report. And they quote in that paragraph, they refer to and quote from the Blewett decision. But if you look at the passage that's quoted in paragraph 136 of the Court of Appeal is being relied on, that passage and Blewett are all about how the court approaches a complaint that something was reasonably required and was wrongly left out on that basis. That analysis is nothing to do with the relevance filter, which arises under Annex 1, paragraph e. So that wide latitude point you get from Blewett is nothing to the point, and there is none of the inconsistency that Lord Anderson would see arising between those two things. Lord, I need to move on, because I'm very short of time now, to deal with ground 4. On ground 4, if I may, you see that I've shown you this already yesterday, we put these points non-CO2 and post-2050, as they're not merely Paris points. They to some extent obliquely relate to Paris, but they were put as very much points arising under section 10.2 and 10.3. Let me remind you in the context of 10.2 that incorporates the Brundtland definition, which is concerned with the relationship between present activities and the impact on future generations. So immediately brings into play a temporal consideration, an unlimited temporal consideration. And that's why we say it's problematic to limit your considerations to 2050, which is what the CCA target focus ended up doing. So that's the context in which those things arise, including the extended Brundtland understanding of sustainable development. Again, the Court of Appeal's characterisation is short, but we say entirely clear and crisp. And we say unimpeachable. If one looks at them, they do all these things together at paragraphs 2, 4, 9 and following. These things did arise before the Court of Appeal as a reasons challenge. That was because it was an appeal against the refusal of permission, at least as the first gateway question. But the Court of Appeal rightly looked beyond that once it had granted permission at the substance of them. And we say the way it dealt with these 2 points is unimpeachable. First of all, just let me show you very directly paragraph 252. You've seen this before. This is where the Court of Appeal is picking forward points made previously. The fundamental point about non-CO2 and post-2050 targets is not the factual question. It's not measuring post-2050 emissions, which is the point Lord Anderson focuses on. It's all about the policy position and targets post-2050. And that's why when the Court of Appeal in paragraph 252 refers to post-2050 target or non-CO2 emissions, that argument is not dealt with by the fact that there was an assessment of post-2050 emissions. The problem, the failure, as the Court of Appeal records it, is to put that into the statutory context. And the statutory context is the sustainability and desirability of mitigating climate change obligations that arise under Section 10. So Lord Anderson says, well, aren't you asking somehow the Secretary of State to make up policy? No, we're not. The policy already exists in the statute. The statute already sets the policy framework. It requires the Secretary of State to look at sustainability and the desirability of mitigating climate change. What he failed to do was to look at post-2050 emissions as predicted in that context, which might have led to a different AMPS, and he failed to look at non-CO2 emissions in that context, which might have led to a different AMPS. Just on the non-CO2 point, again, the Secretary of State, sorry, the Court of Appeal deals with this in dealing with, it's actually Mr. Marici's Respondents' notice, paragraph 257 of the Court of Appeal. What that sets out is it sets out correctly and faithfully the Secretary of State's evidence and explanation, which is, I didn't take into account non-CO2 emissions because of uncertainty around them, because they can't be very precisely quantified. Nobody doubts that. But what then absolutely matters is the Court of Appeal's carefully crafted paragraph 258, the last sentence of which needs to be read carefully and slowly, in line with the precautionary principle, and as common sense might suggest, scientific uncertainty is not a reason for taking something into account at all, even if it can't be precisely quantified. So that is pointing to a logical fallacy on the Secretary of State's part. In other words, just because the Secretary of State says, I can't measure it, therefore I'm going to ignore it. And that, the Court of Appeal says, is a logical fallacy. My Lord Legate.
They use the word precisely quantified. And if that was the point, then they might be right. But in fact, the position is it can't be quantified at all, whether precisely or imprecisely. And that makes a difference, doesn't it? Because then you're just, any number you give is just plucking something arbitrarily out of the air, and that is irrational.
My Lord, but can I just bring myself back to the AMPS stage? We are not here concerned with quantifying the effects of non-CO2 impacts. What we're concerned here with is whether non-CO2 impacts were or should have been a factor in the framing of the ANPS. We're not suggesting, nobody's suggesting the ANPS should have evaluated the number imprecise as it obviously is, unaccessible as it obviously is. It's the concept, and that's what the Court of Appeal is saying there. The Secretary of State, the logical fallacy of the Secretary of State was to go from I can't let me remove the adjective, or the adverb. I'm sorry, I can't quantify this, therefore I'm going to ignore it, and that the Court of Appeal says is an impermissible step. Can't quantify it doesn't mean ignore it when all you're being asked to do in ANPS terms is frame an ANPS test to be considered later. And the problem that arose here was that non-CO2 dropped off the page because it couldn't be quantified. And therefore, Secretary of State didn't even consider featuring it in his ANPS framing, and therefore in whether it's 582 or somewhere else. And in a sense, what all the Court of Appeal is then saying about precautionary principle and common sense is that those are just different ways of explaining that obvious logical flaw. Just because you can't quantify it doesn't mean you ignore it. That's A, common sense. It's B, as it happens, an application of the precautionary principle. This doesn't turn or fail on any legal, as it were, jurisprudential analysis of precautionary principle. It's simply a question of logical fallacy. Secretary of State said, I can't quantify it, or I can't precisely quantify it, therefore I'm going to ignore it and leave it out of account. And that was the failure in terms of the framing of the ANPS, because non-CO2 impacts, whether you look at it through Paris, which clearly is capable of embracing them, as Lord Anderson says, it doesn't specifically mention them, but the point about Paris is it's a temperature-based framework, and so everything that can contribute to temperature-based climate change is part of Paris implicitly. So non-CO2 is within the Paris framework. It's also plainly part of the desirability of mitigating climate change. And the other paragraph alongside this, which is the post-2050 point, those are plainly part of desirability of mitigating climate change, seen in the context of the intergenerational equity points arising from the Brundtland definition of sustainable development. So we get very simple and pithily reasoned, but they're quite straightforward points, pointing out the essentially logical flaws in the Secretary of State's approach to leaving these things out of account. And all we need to say, this is the relief point, is all we need to say is those things shouldn't have been left out of account. And the Secretary of State on grounds 1 and 2 made the concession he made. As it happens, that concession, we say, reads across to the SEA point, because, again, it reads across because what he said was, if I'd taken into account emerging Paris materials, it might have led to a different ANPS, and that's the SEA impact. And then on the non-CO2 points and so on, it's in our submission, it's for Lord Anderson to make good a proposition that the ANPS would necessarily have been the same, or highly likely to have been the same. The burden's on him, and we say that's an impossible mountain to climb, particularly given what the Court of Appeal rightly recorded as being the Court's approach to Section 31, which is set out in the Court of Appeal's judgment. So what we say, obviously Lord Anderson's got to win on all of the individual points, but even if he gets to that point, we say if he doesn't get to that point, then we say there's no basis to as it were, let his clients off the hook on a relief point. And then just finally on the Section 31 points, while Lord Anderson takes points on what the Court of Appeal said about the Section 31 highly likely question, the Court of Appeal also went on to say, this is paragraph 277 of its judgment, furthermore, and in any event, this is one of those cases in which it will be right for this court to grant a remedy on the grounds of exceptional public interest. That's the second limb of the Section 31 test. And that is not challenged. There is no challenge to the court's conclusion on that. And both of these points, both Section 31 highly likely test and exceptional circumstances, are both points in our submission where they are discretionary matters for the court evaluating them, which was the Court of Appeal reaching its position. And an appellate court such as this one, on traditional and familiar principles, should be very slow to interfere with that exercise of discretion unless convinced that it was an irrational one. And we say there's no basis to say here that the Court of Appeal's conclusions on relief were irrational ones. Well, if I could just take a moment, if I may.
Yes.
I'm just going to put myself on mute. My Lords, I'm grateful for the moment to confer. Well, look, can I just make sure I've properly explained to you the relationship between the two steps in SEA, the relevance filter and the reasonably required filter? We simply don't get to the reasonably required filter because we're focused on the relevance filter. And it doesn't matter what evaluation the Secretary of State may or may not have made at the second stage. The fact is he never got to that stage because he filtered it out at relevance. And all we're concerned with in terms of our submissions is getting it within the framework of what needed to be relevant for the Secretary of State's deliberations, because that would have put it into the frame of things that he needed to consider for the ANPS framing purposes. None of that turns on any evaluation of numbers or any such thing in that kind of way. It's simply a relevance question feeding into the ANPS framing.
I see.
Well, and unless I can assist further, and I've said a lot and run over slightly, those are our submissions.
Well, thank you, Mr. Wolf. We'll adjourn now for 5 minutes and then hear Mr. Crossland's submissions for Plan B Earth when we resume. Thank you. We'll now resume the hearing of the Heathrow Airport appeal, and the stage has come at which I have to invite Mr. Tim Crossland, Director of Plan B Earth, to make submissions on behalf of that organisation. Mr. Crossland.
Thank you, my lords and lady. Can you hear me clearly?
Very clearly, thank you.
Lords and lady, on behalf of Plan B, I adopt and support the submissions made by Friends of the Earth in relation to grounds 2 to 4. But I will confine our additional submissions to ground 1, which is the question of whether the government's commitment to the Paris Agreement, and in particular the Paris temperature limit, form part of government policy relating to climate change at the time of the designation of the ANPS and for the purposes of Section 5(8) of the Planning Act. Lord Anderson has given me a lot of ground to cover, including some factual clarifications and corrections. So I'm going to go through this quite quickly, but if it's too quickly, please do let me know.
Certainly.
Begin by addressing the criticism which Lord Anderson levelled at the Court of Appeal yesterday. In his words, as I've noted them down, he said the weakness of the judgment of the Court of Appeal is that it didn't specify the respect in which the Paris Agreement could constitute policy. That charge against the Court of Appeal is unfounded. To the contrary, the Court of Appeal were precise in this respect. At paragraph 216 of their judgment, which is page 295 of the core bundle, they say it is clear, therefore, that it was the government's expressly stated policy that it was committed to adhering to the Paris Agreement to limit the rise in global temperature to well below 2 degrees and to pursue efforts to limit it to 1.5. For convenience, I'll refer to that as the Paris temperature limit. At the time of the designation of the ANPS, the Paris temperature limit was in fact the foundation of the UK government policy on climate change, and the SST, the Secretary of State, was therefore bound to take it into account by virtue of Section 5(8). Had he done so, as the court will see, fundamental questions would have been raised about the ANPS, which, as it were, was simply left unaddressed. It would not be surprising if my lords and lady were left with the impression by Lord Anderson yesterday that the Secretary of State has interpreted government policy on climate change to mean the Climate Change Act 2008 Section 1, 2050 target, and that the ANPS was assessed against that 80% reduction target set out in that section. Indeed, that is more or less what is set out in Hal's written case at paragraph 16, 112 of the core bundle. The Secretary of State followed the CCC's advice in assessing the carbon impact of the scheme in the context of the carbon target in Section 1.1 and the then existing carbon budgets, which had been set with regard to the 37.5 million tonne CO2 planning assumption. as the CCC had advised the Secretary of State not to amend the carbon target or the carbon budgets, and as the UK had not at that time determined to adopt any alternative NDC under the Paris Agreement, it's difficult to see what else those undertaking the assessment could have done. Lord Anderson went on to ask, how could the Secretary of State have assessed a national project against a global temperature goal? Or as Hal put it in their written case at paragraph 36, 1 and 2, that's 118 of the core bundle, the Paris Agreement set a global long-term temperature goal. Such a global aim is incapable of being government policy for the purposes of assessing the potential carbon effects of an individual development scheme. My lords and lady, Lord Anderson has made his submissions to the court on a false premise. The Secretary of State did not assess the AMPS against the carbon target set out in CCA Section 1. He followed the approach of the Airports Commission, which is described in paragraph 7 of the Statement of Fact and Issues. And that approach was to assess the AMPS against two different scenarios. The first of those, the carbon cap scenario, based on a planning assumption of 37.5 megatons CO2 by 2050, a figure which is nowhere to be found in the Climate Change Act. And then he assessed it against a second scenario, the carbon traded scenario. And you'll see at 7.2 of the Statement of Fact and Issues that that was based on a global temperature limit, but not the Paris temperature limit, the historic global limit of 2 degrees Celsius, which the government had rejected in December 2015. My lords and lady will notice that the CCA Section 1 features in neither of those two scenarios, neither the carbon capped nor the carbon traded. And that is not surprising, since the Climate Change Act Section 30, which is at page 14 of the supplementary bundle, says in terms, emissions of greenhouse gases from international aviation or international shipping do not count as emissions from sources in the UK for the purposes of this part, except as provided by regulations made by the Secretary of State. And this part refers to the whole of Part 1 of the Act, which includes both the 2050 carbon target under Section 1 and also the carbon budgets under Section 4. Section 10.2.1 of the Climate Change Act simply requires that reportable emissions from aviation and shipping be taken into account when setting the 5-yearly carbon budgets. That's at 1909 of the core bundle. The Climate Change Act, in other words, does not impose any limits on UK aviation emissions, which is why it was not used as a benchmark for the AMPS, either by the Airports Commission or by the Secretary of State. There's a more substantive reason, however, why the Secretary of State didn't apply the Climate Change Act Section 1 to the AMPS. Section 1 requires a reduction of emissions of 80% by 2050 compared to a 1990 baseline. Far from reducing aviation emissions by 80% by 2050, the planning assumption for aviation, which the Secretary of State did use as a benchmark under the carbon cap scenario, represented a substantial increase in carbon emissions from aviation by 2050 compared to 1990. In fact, what that assumption does is it caps emissions from aviation at their 2005 level by 2050. It's not a decrease at all. Now, according to Howe, this planning assumption was part of government policy. And if you look at paragraph 15 of their case, 111 of the core bundle, They say at the date of designation, the planning assumption, equating to the UK's emissions for international aviation, this planning assumption was adopted by government on the advice of the CCC. My lords and ladies, that shows the difficulty we're in this case, where we don't have the decision maker presenting the facts. We have an interested party presenting the facts, because that is simply incorrect. It's factually incorrect. To the contrary, the Secretary of State was explicit that the planning assumption had not been adopted by the government, i.e. it was not government policy for the purposes of Section 5(8). And that position is set out very clearly by the Court of Appeal at paragraph 217, which is 295 of the core bundle. And there they say, in the amended detailed grounds for contesting the claim, it was submitted on behalf of the Secretary of State that the Climate Change Act does not include emissions from international aviation, which is perfectly correct. It was said that the Committee on Climate Change had advised that emissions from the UK aviation should be no more than 2005 levels in 2050. This is sometimes referred to as the planning assumption. It was said, in other words, said by the Secretary of State, that the government had not yet decided whether to accept that advice. A decision on this was deferred by the aviation policy framework and would be considered as part of the emerging aviation strategy to be adopted in 2019. This would re-examine how the aviation sector can best contribute its fair share to emissions reductions. That position is summarised more briefly in the Statement of Facts and Issues at paragraph 34, 74 of the core bundle. A decision on whether to accept this planning assumption or aviation target was deferred by the APF for consideration as part of the emerging aviation strategy. Crucial factual error, simply wasn't and expressly wasn't part of government policy. In other words, neither the CCA nor the planning assumption were applicable government policy for the purposes of Section 5(8). If we turn to the Department of Transport's own projections, we can see why there might have been some hesitation on the government's part to accept the committee's recommendation regarding the planning assumption. My lords and ladies, please turn to 1481 of the core bundle. And you should see at the top of the page, table 36, total UK international and domestic departing aircraft CO2 forecasts. And in the top left-hand corner, you see a baseline. And so we're starting in 2015. This is without any new expanded capacity at Heathrow. There's a central estimate for emissions of 36.2 megatons of CO2. In other words, below, but not very far away from that planning assumption for 2050.
I'm so sorry, Mr. Crossland, is that taking the blue line as at 2050 or what?
It shouldn't be a blue line at all. It should be a grid that I'm looking at.
Oh,
it's 1481 of the core bundle. It's a bit confusing because there are two different page numbers.
Right, so it's the numbers at the top of the page you're looking at.
Yes.
Yeah,
so you've got a baseline LGW second runway, LHR extended northern runway, and then the LHR northwest runway, which.
Yes, thank you.
So the central estimate in 2015, 36.2. But if we come to the central estimate for 2050, for the proposed expanded Heathrow, which is the bottom right-hand corner, we see that the central estimate is 39.9 megatons of CO2. In other words, in excess of that planning assumption. And we see that even on the lowest end of the Department of Transport's own estimate, 38.1, it's already in excess of that planning assumption. And at the high end, it's very substantially in excess, 44.1 million tonnes of carbon dioxide by 2050. So, my lords and ladies, it's not for us to speculate on the government's motivations, but there may be some reason there why they were slow to accept the CCC's advice on that point. In any event, it does illustrate the distinction between CCC advice and government policy, which is important throughout the case. For the purposes of Section 5.8, however, whether or not the AMPS was consistent with the planning assumption was, strictly speaking, irrelevant, because the planning assumption was explicitly not government policy. A decision had been taken not to accept it. So, my lords and ladies, we now turn to the only other scenario that was actually considered by the Secretary of State, and that was the carbon traded scenario, which approached aviation as an international sector constrained only by the global temperature limit. And for reasons that neither he nor his officials nor Lord Anderson have explained at all, the global temperature limit they adopted was the discredited, inadequate target of 2 degrees. Turning to paragraph 14 of the Statement of Facts and Issues, we see that the Department of Transport applied the same 2 scenarios to their analysis for the final version of the assessment of sustainability, the carbon capped and the carbon traded. And then turning to paragraphs 20 to 21 of the SFI, we see the same in the post-adoption statement. Carbon emissions has been considered using 2 future scenarios: meeting the UK's overall emissions in the carbon cap case, meeting the UK's commitments under any future international agreement in a carbon traded case, was assessed against international agreement, unnamed. It was understandable that the Airports Commission should use the historic 2-degree target, because the Airports Commission's final report was published in July 2015. In other words, before the Paris Agreement, before the change to the global temperature limit. By June 2018, the time of the designation of the AMPS, the Paris temperature limit has been in place for more than 2.5 years. But nevertheless, it's confirmed by Caroline Lowe that the Secretary of State continued to use the 2-degree limit, even while knowing it was no longer the appropriate limit. And if we turn to paragraph 469 of Caroline Lowe's first statement, that's page 784 of the core bundle. She says the carbon traded scenario assumes aviation emissions are tackled at an international level. Under this scenario, overall CO2 emissions are set at a cap consistent with a future global goal to limit global warming to 2 degrees. And then at paragraph 487, which is page 790, she says, my team continued the Airport Commission's approach of making an assessment based on 2 different carbon scenarios, carbon traded and carbon capped, to capture the uncertainty around future carbon policy. The principles and assumptions behind the carbon traded scenario remain unchanged. In other words, no change to the 2-degree limit. For the moment, my lords and ladies, the central point is this. Howe's case is that a global aim is incapable of being government policy for the purposes of assessing the potential carbon effects of an individual development scheme. And that case is fatally flawed because the AMPS was assessed against a global temperature limit. The problem is it was assessed against the wrong one, the old historic limit, not the current Paris temperature limit, which the Court of Appeal correctly identified as current applicable government policy. And Lord Anderson has offered us, the court, no explanation whatsoever for why it was possible to assess the AMPS against the wrong temperature limit, but it wasn't possible to assess it against the correct global limit, which was the Paris temperature limit. Rather, Lord Anderson's tactic has been to draw a veil over the Secretary of State's reliance on the carbon traded scenario and the use of the 2-degree limit. He doesn't mention it at all. He simply hopes to wish it away. My lords and ladies, to understand the central role played by the global temperature limits in UK government policy, we need to look only to the history of the Climate Change Act itself. Without the anchor of the global temperature limit and the associated global carbon budget, setting national emission reduction targets would simply be picking numbers out of a hat. And we can see this most clearly if we go to the chronology, which is 93 of the core bundle. And page 1, 2000. The Royal Commission on Environmental Pollution recommends UK emissions reductions of 60% by 2050 based on a 2-degree global limit. Then 2007, the House of Commons Environmental Audit Committee recommends a more stringent target than 60% for consistency with the 2-degree limit. And then October 2008, letter from Lord Turner to Ed Miliband recommending a 2050 carbon target of at least 80% reductions for emissions for consistency with the 2-degree limit. And then the Climate Change Act Section 1 is brought into being on the basis of that advice. Particularly instructive is the discussion before the Environmental Audit Committee, and this is 854 of the core bundle. You'll see at paragraph 63, they say the draft bill contains provisions to place an obligation on the government to achieve at least 60% reduction from 1990 levels. In paragraph 64, the majority of evidence we considered suggested strongly that the 60% target is inadequate. The target was based on a recommendation by the Royal Commission. The Royal Commission's overarching aim in making this recommendation was that global warming should be limited to a rise of no more than 2 degrees. According to the science of the time, and they go on to explain the technicalities of that, and they say this is something the government itself recognises. And then at paragraph 65, the Secretary of State for Environment, Food and Rural Affairs confirmed to us that the government was still completely committed to limiting global warming to a rise of 2 degrees Celsius. By stretching the dangers even of this level of warming, he emphasised the reasons why the UK were committed to holding a rise in temperature to no more than 2 degrees. Says, just to put that in perspective, I was told that with a 2-degree average change, it will not be uncommon to have 50 degrees centigrade in Berlin by mid-century. So 2 degrees is something pretty unprecedented. And then at 69, the committee says the government's policy just emphasise that word policy towards the UK's 2050 target is incoherent. The government remains committed to limiting global warming to a rise of 2 degrees centigrade, but it acknowledges that according to recent research, 60 degrees in the bill is very unlikely to be consistent with that. Following that report, following that critique, the embryonic Committee on Climate Change was charged with reviewing the adequacy of the 60% limit. At 859 of the bundle, we see the letter that Lord Turner writes to the then Secretary of State, Ed Miliband. And if I can take the court to 861 of the bundle, the first main paragraph says, to determine a UK emissions reduction target, we first considered the global target, what a global target should be, and then the UK's appropriate contribution. The global emissions target needs to be based on analysis of the science. The crucial issue is what level of global temperature should the world seek to avoid. And then on page 863, our recommended 80% target, we recommend that it covers all sectors of the economy. It should be a minimum target for those sectors. My Lords, if we go back to the chronology now, which is page 94, we see how a very similar process is adopted on the global level. So in 2012, on the chronology, you'll see the Conference of the Parties, which is the governments, including the UK government, commissions an expert review, the structured expert dialogue, into the adequacy of the 2-degree temperature limit. And then over the page, it's 3 years later, in fact, before that expert review concludes, May 2015, the final report of the structured expert dialogue, the guardrail concept in which up to 2 degrees of warming is considered safe, is inadequate. And that then informs the Paris Agreement, the decision to impose a more stringent limit. In March 2016, we have the statements from Leadsom and Rudd, the Secretaries of State, committing the UK to introduction of a new target. The 17th of April 2018, this is just following the chronology. The government announces at the Commonwealth Heads of Government meeting that after the IPCC report, it would seek advice from the CCC on the implications of the Paris Agreement for the UK's long-term emissions reductions targets. Then October 2018, we get the IPCC report onto 1.5 degrees. Following that, in May 2019, the CCC publishes its net zero advice, recommending the new net zero target, and in June 19, it becomes law. In other words, this whole process is anchored to the global temperature limit and what it implies. And turning to 1837 of the core bundle, we can see how ultimately in May 2019, the committee's advice to the government was framed exactly in terms of meeting the Paris temperature limit. A net zero target for 2050 will deliver on the commitment that the UK made by signing the Paris Agreement. A net zero target for 2050 would respond to the latest climate science and fully meet the UK's obligations under the Paris Agreement. It would constitute the UK's highest possible ambition as called for by Article 4 of the agreement. And they then explain how it relates to both limbs of the Paris temperature goal, the well below 2 degree limb But they also say if replicated across the world and coupled with ambitious near-term reductions in emissions, it would deliver a greater than 50% chance of limiting temperature increase to 1.5 degrees. So again, my lords and ladies, we see how the global temperature limit serves as the foundation for both national and international policy on climate change. The government's policy commitment is to the temperature limit, and then the CCC's role as the technical advisor is to provide the technical advice on the domestic emissions reductions under the Act consistent with that limit. And the history to date is the government simply accepts those recommendations. The government sets the policy. This is the temperature limit we want to make a contribution to. The Committee on Climate Change says, well, this is what you need to do. Government commitment to that temperature limit is clearly the government's policy. The Climate Change Act target is just one mechanism for delivering on that policy, because as we've seen, the CCA excludes, for example, emissions relating to aviation and shipping, which nevertheless are. My Lord's Legate.
I just wondered if you could help me by clarifying the relationship between the temperature limits in the Paris Agreement and net zero, because I noticed that Andrea Leadsome's statement, which you rely on, that we need to take the step of enshrining the Paris goal of net zero emissions. Is that the Paris goal, or is it something that the UK thinks it should try to achieve in order to aim at the Paris goal, or what's the connection between the two?
My Lord, yes, there are two different parts of the Paris Agreement. The first is the temperature limit in Article 2. Yeah. But then there's also a commitment to introduce getting to global net zero at some point in the second half of the century. That's what's said in the Paris Agreement itself.
Well, just give me the reference, if you would, to where in the agreement.
I believe
it's a different goal from the temperature.
The crucial point, my lord, is that the net zero is not one of the objectives of the agreement. The objectives of the Paris Agreement are set out in Article 2. So everything else in the agreement aims at those objectives. In other words, NDCs, nationally determined contributions, net zero, all of those additional elements of the agreement, they must aim at the global temperature limit. That's quite clear in the Paris Agreement. And
it's a goal towards another goal.
Yes, it's a milestone towards the goal. It's simply recognition that the only way to contain climate change eventually is just to stop emitting CO2 altogether. That's what it is. But because it is an international treaty, it's not specific about the timing. What everybody needs after the Paris Agreement is scientific advice from the IPCC on when exactly that net zero will need to be. And that's what we get in the October 2018 report from the IPCC. And the IPCC then say, to have any chance of maintaining the Paris temperature limit, global carbon emissions will in fact need to reach net zero by 2050.
But it's Article 4.1, is it, of the agreement, which is aiming to achieve a balance between emissions and removals in the second half of this century?
My lord, yes. Thank you very much. So, as well as the CCA target, because it's a global temperature limit, and the government seeks other ways to enforce its policy commitments, including, for example, its diplomacy. And we hear about how it's using its diplomacy to influence other countries to take that limit seriously. And we will come to the detail of that shortly. If there's one minor criticism, we say, to be levelled at the Court of Appeal, it's this. If we turn to paragraph 13 of the Court of Appeal's judgment, which is 232 of the core bundle, see the list of issues set out by the Court of Appeal. Issue 4, whether the Divisional Court erred in holding that neither the Paris temperature limits were part of government policy for the purposes of the Planning Act. Issue 5, whether the Divisional Court erred in holding that the 2-degree temperature limit was a relevant consideration. Then if we turn to paragraph 184 of the Court of Appeal's judgment at 285, Court of Appeal says the issues concerning the UK's commitments on climate change can conveniently be simplified. Climate change issues 3, 4, 5 and 6, in other words, those two we've just looked at, did the government's commitment to the Paris Agreement constitute government policy on climate change, which the Secretary of State was required to take into account? In other words, they conflated the question of whether it was appropriate for the Secretary of State to rely on the historic 2-degree limit with the question of whether the Paris limit was the correct limit for the purposes of Section 5.8. And one can see completely why they did that. Because if the Paris limit was the correct limit, it follows logically that the 2-degree limit was the wrong limit.
Can I ask, Mr. Crossland, we saw yesterday advice from the Climate Change Committee to the effect that although the target set by the 2008 Act had been directed towards achieving a limit to the rise in global temperatures of 2 degrees, it was, in their view, potentially compatible with the more stringent requirements of the Paris Agreement, with a number of changes that have taken place since 2008, for example, technological changes. Are you going to deal with that point?
I will come to that shortly, of course. That's a crucial issue. My Lords and Ladies, the only issue we take about the Court of Appeal's approach, that simplification, which logically made complete sense, was by not specifically addressing the Secretary of State's reliance on the 2-degree limit, they made it somewhat less clear what had actually occurred. And to some extent, that has opened up the way for Lord Addison's submissions, which simply ignore what it was that the Secretary of State took into account. My Lords and Ladies, I've been referring to the 2-degree Celsius limit as inadequate. It's important to explain why that's so. After all, to the untrained ear, the distinction could seem small between 2 degrees and well below 2 degrees, aiming for 1.5. To the contrary, it is a distinction of vital importance. The Divisional Court provides some initial context for this at 575 of their judgment. That's 457 of the core bundle. They say from about 2010, concerns emerged as to whether keeping global average temperatures to around 2 degrees Celsius would be adequate to combat climate change effectively, because it appeared that CO2 was being absorbed at a slower rate than anticipated, and some of the effects of global warming appeared to be emerging quicker than expected. And we've already seen how in 2012, the UK government and others commissioned an expert review into that question. And if we go to the core bundle 1217, we see at paragraph 108, this is the final result of that expert review. We've already seen how they said that the guardrail concept, 2 degrees, is inadequate, but at 108 they say experts emphasised the high likelihood of meaningful differences between 1.5 degrees Celsius and 2 degrees Celsius of warming regarding the level of risk from ocean acidification and of extreme events or tipping points. So the Paris Agreement was informed by that 3-year expert process. And if we turn to the decision which accompanied the Paris Agreement at Core Bundle 2096, we see that it said that this is the 5th paragraph of the preamble, the 5th paragraph from the bottom of the page, emphasising with serious concern the urgent need to address the significant gap between the aggregate effect of parties' mitigation pledges in terms of global annual emissions of greenhouse gases by 2020 and aggregate emission pathways consistent with holding the increase in the global average temperature to the Paris temperature limit. So that's adopted by the UK government. In other words, the parties themselves recognise that their initial NDCs in aggregate, which aimed at the old 2 degree limit, not at the Paris temperature limit, because they'd been submitted in advance, they recognised they were inadequate to meet the Paris temperature limit, and that urgently required correction. Somewhat closer to home, we have the government's own clean growth strategy, published in October 2017. This is a key document because it's not in dispute that this document represents government policy on climate change and was policy published under the CCA 2008. And it's worth looking at this in the original. This is 1525 of the bundle. See the Prime Minister's foreword. On the world stage, we were instrumental in driving through the landmark Paris Agreement. The next page, the Minister's foreword. Following the success of the Paris Agreement, where Britain played such an important role in securing the landmark deal, the transition to a global low-carbon economy is gathering momentum. And then the next page, this is now 1527 of the bundle. The UK played a central role in securing the 2015 Paris Agreement, in which for the first time goes on, and it then says the actions and investments that will be needed to meet the Paris commitments will ensure the shift to clean growth will be at the forefront of policy and economic decisions made by government and businesses in the coming decades, at the forefront. And crucially, my lords and ladies, if we turn on a couple of pages to 1530, the government explains exactly why it has adopted the Paris temperature limit as its policy and rejected the 2 degree limit. It says scientific evidence shows that increasing magnitudes of warming increase the likelihood of severe, pervasive, and irreversible impacts on people and ecosystems. These climate change risks increase rapidly above 2 degrees Celsius, but some risks are considerable below 2 degrees Celsius. This is why, as part of the Paris Agreement, countries committed to, and then the Paris temperature limit. And then another crucial point on the same page, as part of the Paris Agreement, countries also committed to reduce or limit their greenhouse gas emissions. These are contained in their nationally determined contributions. A number of studies consider how close these commitments bring us to staying below 2 degrees and estimate that if they were met, we would be on a path to a global temperature rise of 2.7 to 3.7 degrees by 2100. In other words, recognition by the government, first of all, that it's vital to maintain the Paris temperature limit. Secondly, that aggregate NDCs are nowhere near good enough. So again, it's that same structure. The policy is the temperature goal. That's what everybody's aiming at. This position is restated in the government's 25-year plan, which was published in January 2018. And the relevant extract is paragraph 53 of the Statement of Facts and Issues. That's 79. My Lord Legate.
I expect you'll be coming to it, Mr. Crossman, but you said just now that the Paris temperature limit is the policy. I mean, there's a difference, isn't there, between an aspiration of reducing global temperatures and a policy formulated by the UK to play its part in seeking to achieve that. The policy is not the aspiration. It's the formulated plan for attempting to get towards it.
My Lord, the policy in our submission, in the ordinary sense of the word, is intention. It is what you're aiming at. It is the goal. And the reason for looking at the reason and the rationale for that policy just now is to see that it must be more than an aspiration. The government is saying is over and above 2 degrees, the consequences, the risks become intolerable. So that has to be more than an aspiration to stay below that. That has to be a clear policy commitment. And we will...
Well, that doesn't necessarily follow. I mean, if, for example, other countries which are responsible for far larger quantities of emissions are not prepared to adopt or achieve net zero targets, then essentially, if the UK were committed in an overriding way to achieving that, we wouldn't simply have a net zero. We would be going backwards and effectively, go back to pre-industrial. It would be, have a negative situation.
My Lord, clearly that is right, that the UK cannot do this on its own. That is a given, and that is why international cooperation and leadership, in particular by the historically high emitting countries, is so vital. That principle of leadership is not just an aspiration, it's there in the Paris Agreement, it's there in the UNFCCC. The historically high emitting countries must show leadership. So the one thing that is certain is that if those countries don't show leadership and themselves do not aim for that global temperature limit and adopt appropriate policies, then nobody else is going to. So it's a little bit like some sort of game theory. The only chance that one has is to demonstrate through leadership. And we'll come on to this. We'll see more about the government's policy, not from my own mouth, but from the government's mouth in relation to that side of it, the diplomatic side of it. So the core bundle, page 79. This is the SFI paragraph 53, the government's 25-year plan, exactly the point, my lords and ladies, we've just been discussing. We will provide international leadership and lead by example in tackling climate change. We will use our diplomacy on the international stage to encourage more ambitious global action. Using our leading role in the UNFCCC, through which the Paris Agreement was established, we will urge the international community to meet the goals enshrined in the text. This is vital for future environmental security. Current global commitments under the agreement are insufficient to limit average temperature rise to well below 2 degrees Celsius. In other words, the government is expressly saying that given the shortfall in terms of action, what's needed is leadership, what's needed is diplomacy, which can only be achieved if the UK government itself shows that profound commitment to the Paris temperature limit, which it did so much to advance. And of course, the message that comes out of one of the leading countries in advancing that agreement says, well, actually, our policy is still the old 2 degrees Celsius. That's not going to encourage anybody to take the Paris Agreement seriously. My Lord Legate.
You could say I've got an aspiration or a goal, that there should be peace throughout the world. But that doesn't mean that that's a government policy, does it? In the sense that we're talking about policy for the purpose of, for these purposes. Surely it's contemplating some kind of thought through, developed, articulated plan. Well, not just general statements of idealism.
Of course, that's correct, my Lord. But if that is the case, then why did the Secretary of State take account of the global 2 degree limit? Because you could say exactly the same about that. That is also a global aspiration. That is also a goal.
He didn't claim that that was a policy. There's never been said that the 2 degrees is a policy for these purposes. That had to, reasons for which had to be given in the statement. We're dealing with your ground one.
Indeed, my Lord, but we've seen already that the only materials that the Secretary of State took account to give effect to discharge his duty under Section 5.8 was the carbon cap scenario, which was the planning assumption, and the carbon traded scenario, which was based on the 2 degree limit. In other words, that's how he's saying he's discharged Section 5.8. And we're saying, well, if you looked at the global temperature limit, why didn't you use the correct one? Why did you use the wrong one, the old one? And my Lord, we will come a little, in a short time, we will see actually how the Paris temperature limit would have guided the Secretary of State's decision in a very concrete way, not an abstract, idealistic way at all. That will become clear soon.
Now, in order to complete that that discussion, we've run on somewhat past 1 o'clock, so we'll adjourn now and resume at 2.
Thank you, my Lord.